Hello, you all. I welcome you all to read Bear It with me. Now, this is part 2, and I'll be starting with chapter 9 Investigation. I think that's important for the judicial examination because the earlier section only deals with the incorporation and the rights or the liabilities of the partners, which are which are very technical, so may not be asked in the daily judicial services. So let's begin with section 43. This is about the investigation of the affairs of the limited liability partnership. So, which authority would do it? It's the central government. That central government will appoint one or more competent person as inspectors to investigate the affairs of the limited liability partnership, and this can be done if there are three situations that exist. First, the tribunal suo motu asks the central government. Second, the application is being received from the one-fifth of the partners. For example, if there is a 10-member LLP, then one-fifth will be two people. So two of the partners are given an application with this regard. Thirdly, any court by an order declared that the affairs of the limited liability partnership ought to be investigated. In these three situations, the central government will appoint one or more competent person as inspectors. Clause 2. Central government may appoint one or more competent person as inspector to investigate the affairs of a limited liability company and to report on them in such a manner as it may direct. It's again, so first is with respect to a particular situation, that is where the court or the tribunal is being involved. Second is a general provision. This will apply as given in clause 3, which says that if not less than one-fifth of the total number of partners of the LLP make an application along with supporting evidence and security amount as may be prescribed. So the LLP partners make an application along with evidence and the security. I think this is also the same. 1 minute. This has also been given under section 44, the same thing. So in clause 3, you see that it asks for supporting evidence and the security amount. This is section 43 only. Then clause B, if the LLP partnership makes an application on that affairs. So first is when the partners make an application, second is when the LLP makes an application, and third is if the central government itself is of the opinion that there are certain circumstances. What are those circumstances? First is the fraud. That is, the LLP or the partners are doing some fraud on the creditors or any other person, or they are doing their business in a unlawful and a fraudulent manner. Second is when the affairs of the LLP are not being conducted as per the LLP Act. Third is when the report of a registrar or any other investigating agency is being received and which shows a sufficient reason that the affairs ought to be investigated. Okay, there's just one correction that here it is not section 43. 43 is what we have been reading. And secondly, since this section already provides for evidence and security, the requirement of evidence and security in section 44 is with respect to clause A. So here you will read section 44. Section 44. An application by partners of the limited liability partnership under clause A of subsection 1 of section 43 shall be supported by such evidence as the tribunal may require for the purpose of showing that the applicant have a good reason for requiring the investigation, and the central government may, before appointing an inspector, require the applicant to give security of such amount as may be prescribed for payment of costs to the investigation. Just 1 minute. Okay. So here it asks for two things: evidence, and other is security. Okay, here, just write it here so that it's easier. Fraud, not as per the act and the report of the registrar or other investigating body. Now, application. Security is to for cost of investigation के लिए, and evidence is to know the good faith. Now, section 45 is who cannot be an inspector. It says firm, body, corporate, other association cannot be an inspector. Now, section 46. Power of inspector to carry out investigation into affairs of related entities. If an inspector appointed by the central government to investigate the affairs of a limited liability partnership thinks it necessary for the purpose of his investigation to investigate also the affairs of an entity which has been associated in past or is presently associated with the limited liability partnership or any present or the former partner or designated partner of the limited liability partnership, the inspector shall have the power to do so and shall report on the affairs of the other entity or partner or designated partner so far as he thinks that the result of his investigation thereof are relevant to the investigation of the affairs of the limited liability partnership. So this section talks about that the inspector can also investigate first any entity. Entity has been defined in section 2 of this act as a partnership firm. Second, any former or present partner. And thirdly, wait, and thirdly, designated partner. So these are the three people who can be investigated, correct? Okay, so this is saying that the inspector can also investigate these three and these three people or these three bodies if if they think that the result of this investigation would be relevant for the investigation of the thinks that the result of the investigation would be relevant to the investigation of the affairs of the LLP. This is clause 1. Clause 2. In the case of any entity or partner of the designated partner referred to in subsection 1, the inspector shall not exercise his power of investigating into and reporting on its or his affairs without obtaining the prior approval of the central government. इसके लिए prior, but there is a condition. Condition is prior approval of whom? Central government. Provided that before according approval under this subsection, the central government shall give the entity or the partner or the designated partner a reasonable opportunity to show cause why such approval should not be accorded. This is a natural justice principle, right to be heard. Hearing opposite party. Okay, so this is what the section 46 is about. So we started with section 43, which is about the investigation. It just talks about who will appoint the inspectors for the purpose of investigation, when an investigation can be conducted. It can be by court, tribunal, applicants, LLP, or the central government. So there are five circumstances. Then section 44 just deals with just further procedural requirement has been given about the security and evidence. 45 deals with who cannot be an inspector. 46 talks about inspector to carry out investigation of any related entity, partners, or a designated firm. Then there are certain conditions with respect to this. Section 47 is the production of document and evidence. It shall be the duty of the designated partner and the partner of a limited liability partnership to preserve and to produce before an inspector or any person authorized by him in this behalf with the previous approval of the central government all books and papers of or relating to the limited liability partnership or as the case may be the other entity which are in their custody or the power otherwise to give to the inspector all the assistance in connection with the investigation which they are reasonably able to give. So it casts the duty on the designated partners. It's a duty of designated partners. It's not a duty of other partners, not the duty of LLPs, not the duty of employees. It's a duty of designated partners to produce and preserve all the documents which is required by the inspector or any other authority, or provide all assistance to preserve and produce. Okay. The inspector may, with the previous approval of the central government, may require an entity other than the entity referred to in subsection 1 to furnish such information to or produce such books and papers before him or any person authorized by him in this behalf, with the previous approval of that government, as he may consider necessary, if the furnishing of such information. So just as section 46, which talks about investigating some related entity, the section subsection 2 of 47 deals with inspecting the documents or the books or some papers of other entity. For this also, previous approval of the central government is required. And then once you obtain that approval, then it is the duty of those entities to produce or to furnish such information or production of the books, papers which are relevant and necessary for the purpose of investigation. The inspector may keep in his custody any book and paper produced under subsection 1 or subsection 2 for 30 days, and thereafter shall return the same to the limited liability partnership, other entity or individual by whom or whose. So this is the power. So the investigating agency can ask for any document from the entity which is under investigation, from any entity or individual which may not be under the investigation, but with the prior approval of the central government. They may keep those documents for 30 days and provided that the inspector may call for the books and papers if they are needed again. That is recalling. May call again, provided further that because it says that you can keep it for 30 days for, so what if you need it further, then they may call it again, provided further that if certified copies of the books and the papers produced in the subsection 2 are furnished to the inspector, he shall return those books and papers to the entity or the person concerned. Because certified copies हैं तो भी you have to return. An inspector may examine on oath any of the person referred to in subsection 1 with the previous approval of the central government, any other person in relation to affairs of the limited liability partnership or any other entity as the case may be. Okay, so this is about examination on oath. So inspection के लिए you, if you are conducting an investigation, what are the things you need for investigation? You need documents as evidence. You need people to give testimony or being a witness in a general sense, right? So this is what they are. First, they're talking about document. What documents you can call for? Uh, then they talk about how long you can keep those documents. Now they're talking about examination on oath. So again, you can examine any person. You can, so in the first, so in the second situation, so we are dealing two situations. First, the entity which is under investigation, and second, which are related to the entity which is under investigation. So in the second circumstances, we are always seeking the approval of the central government, but not in the case of first. Why is that so? It is so because the investigating agency has been appointed by the central government. So there is already an implied approval which is existing, right? Because when we started section 43, the inspection or the investigating agency is by the approval of the central government only. So there is already an approval with respect to all the acts which are required to be done by the inspecting agency. So that's why we don't need permission in the first case, but we do need permission in the second case. Okay. May administer oath according. So now start. Clause C. May administer own oath accordingly and for that purpose may require any of those persons to appear before him personally. If any person fails without reasonable cause or refuses to produce before an inspector or any other person authorized by him in this behalf with the previous approval of the central government any book or paper which it is his duty under subsection 1 or subsection 2 to produce, or to furnish any information which is his duty under subsection 2 to furnish, or to appear before the inspector personally when required to do so under subsection 4, or to answer any question which is put to him by the inspector in pursuance of that subsection, or to sign the notes of any examination, he shall be punishable with fine. So any contravention to this section by any. So there are three, four things that this section provides for. First is production of documents. Second is examination on oath. Third is to appear personally and answer the questions. And fourth is to give any other information. Or as it says, and the clause D says, sign the notes of any examination. So if there is contravention with respect to any of these acts, it shall be punishable with fine, which shall not be less than 2000 rupees. So up to 2000, but which may extend to 25,000. And with a further fine which shall not be less than 50 rupees, but which may extend to 500 rupees for every day after the first day after which the default continues. And this is a fine, but 50 से लेके 500 rupees per day की penalty लग सकती है. The notes of any examination under subsection 4 shall be taken down in writing and signed by the person whose examination was made on oath. And a copy of such notes shall be given to the persons who examine on oath and thereafter be used as an evidence by the inspector. So you will call a person to examine an oath. Okay, so examination on oath is what? You will ask the person, you will ask certain question. You will question that person on oath. So on oath meaning that if the person lies, that can attract the penalty because you are legally bound to say the truth now. So when this person is examined on oath, you will take down whatever the person is saying in writing that will be signed by the person who is examined. So if I have been examined, I will sign it, and a copy of that note will be taken given to the person. So my examination would now be used as a evidence by the inspector. This is an important thing because if you know the CRPC, the examination by police is not done on oath. Firstly, secondly, when the examination or the investigation is done by the police, that cannot be used in the evidence. So this is an important point here. Hmm. Okay. Let's revise quickly whatever we have done. We started with section 43. This is about investigation. This section only talks about when the investigation inspection can begin. There are five situations. Section 44 is extension to section 43. It talks about uh, when the partners are giving their application for investigation, they have to also give evidence for security. Section 45 talks about who cannot be an inspector. Section 46 talks about what whose inspection can be carried out by the investigation agency, that is the entity who the entity whose investigation. So it just basically says that you can also investigate not just the entity whose investigation you have been appointed, but also any related entity. 47 talks about the documents and the evidences collection and the examination on oath and making and what will happen if there is a contravention to that provision. Now section 48 is the seizure of document by the inspector, where in course of investigation the inspector has reasonable ground to believe that the books and the papers of or relating to the limited liability partnership or other entity or the partner or designated partner of such limited liability partnership may be destroyed, mutilated, altered, falsified or secreted. The inspector may make an application to the judicial magistrate of first class or as the case may be to the metropolitan magistrate having jurisdiction for an order for the seizure of such books and papers. That's where our roles come in. So DJS may we will become a metropolitan magistrate. So that's where our role come in. Our role is to give them. So if there is any inspector who want to seize any document, tell me under CRPC which section talk about seizure, search and seizure, seizure of documents. Which section? And 2 CR. It is 102 CRPC which talks about seizure. Another previous provision are with respect to search. 102 seizure by a police officer, right? Okay. Here the Metropolitan Magistrate will give the permission in which situations? So when the inspector or the investigating agency has a reasonable ground to believe that those would be destroyed, mutilated, altered, falsified, secreted, and the inspector then make an application to the judicial magistrate first class. After considering the application and hearing the inspector, if necessary, the magistrate may by order authorize the inspector to enter with such assistance as may be required the place or places where such books and papers are kept, to search that place or whose place in the manner specified in the order, and to seize the books and papers which an inspector considered it necessary for the purpose of this his investigation. This is similar to one of the this is similar to one of the section of CRPC where somewhat similar to section 94, where you take the permission to enter a place where the suspicion of stolen property or objectionable property is there. Correct. Now, that's what it says, na? That you can enter, you can search, you can seize. This is the same as that. The inspector shall keep in his custody the books and the papers seized under this section for such period not later than conclusion of the investigation as he consider necessary, and thereafter shall return the same to the concerned entity or the person from whose custody or power they were seized, and inform the magistrate of such return. And then they have to return it, provided the books and the papers shall not be kept seized for a continuous period of more than 6 months. Is a time limit. These are the things which are asked in paper because you tend to get confused. 6 months, not 60 days. Provided further that the inspector may, before returning such books and paper as aforesaid, place identification marks on them or any part thereof, save as otherwise provided in this section. Every search or seizure made under this section shall be carried out in accordance with the provision of Code of Criminal Procedure relating to search or seizure made under that code. So you follow what? Section 100. You follow section 101, section 102. Those are the provision we dealing with search and seizures. We also have section 91, 2, 92, 93. 93 is the general search. 94. Then okay, 90, 100, 100. These are the provisions you have to follow. That you can enter any place. If the ingress has not been given, you have to call the witnesses. You have to prepare a search memo to be signed. You deliver a copy to the person. All of those provisions have to be followed. Section 49. Inspector's report. The inspector may, and if so directed by the central government, shall make interim report to the government, and on the conclusion of the investigation, shall make a final report to the central government, and any such report shall be written or printed as the central government may direct. So it talks about two things. First is the interim report. Second is the final report, and you submit that to the central government because that's the authority which is appointed it. Now it will be written or printed as the central government direct. Then the central government shall forward a copy of any report other than the interim report made by the inspectors to the limited liability partnership at their registered office, and also to any other entity or person dealt with or related to the report, and may, if it thinks fit, furnish a copy thereof on request and on payment of the prescribed fee to any person or entity related to or affected by the report. So, investigation investigation completed, report to central government, then they will forward it to the LLP or related entity, or any other person. This is what the section 49 talking about. So section 43 about investigation, section 44 is continuation, which talks about evidence and security. Section 45 deals with who cannot be an inspector, the firm, body, corporate, etc. Section 46 deals with the investing who can be investigated, just entity plus the related entity plus designated partners plus other partners. Section 47 talks about production of documents, etc. Section 48 talks about what is section 48? Seizure. Section 41 seizure of the documents with the permission of GM1 or the MM1. For that purpose, that person can search, enter a place, search a place, seize a book, keep it for the 6 months, and then return. And the 49 is the submission of the report. Okay. Now, 50 is a prosecution.